Maybe tomorrow we'll see it.
Yeah.
Okay.
Conosci tutti, questa claro que tudo bom.
To take some explanations.
No problem.
Yeah.
At the Faculty of Law at the University of Ottawa. He has extensive experience as counsel in the context of international fisheries and boundary arbitrations, and has also appeared as counsel before this court in proceedings involving the interpretation of a judgment rendered in a case between Cambodia and Thailand. In the framework of the World Trade Organization, he has appeared as counsel before that organization's dispute settlement panels and appellate body, and has also served as a member of several WTO panels. In addition, he has been a member and chair of various arbitral tribunals, including cases brought under the Convention on the Settlement of Investment Disputes between states and nationals of other states, and Chapter 11 of the North American Free Trade Agreement. Judge McRae is the former editor-in-chief of the Canadian Yearbook of International Law and has published widely on international law, including on law of the sea and international trade law. He is a member of the Institut de Droit International, a member of the Royal Society of Canada, a companion of the Order of Canada, and an officer of the New Zealand Order of Merit. He was member of the International Law Commission from 2007 to 2016. Judge McRae previously served as Judge ad hoc in the case concerning obligation to negotiate access to the Pacific Ocean, Bolivia versus Chile, the case concerning alleged violation of sovereign rights and maritime spaces in the Caribbean Sea, Nicaragua versus Colombia, and the case concerning the question of the delimitation of the continental shelf between Nicaragua and Colombia beyond 200 nautical miles from the Nicaraguan coast, Nicaragua versus Colombia. He is currently sitting in the case concerning Guatemala's territorial, insular, and maritime claim, Guatemala versus Belize. I shall now invite Judge McRae to make the solemn declaration prescribed by the statute, and I request all those present to rise.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank Judge McRae. Please be seated. I take note of the solemn declaration made by Judge McRae and declare him duly installed as Judge ad hoc in the case concerning Embassy of Mexico in Quito, Mexico versus Ecuador. Je vais à présent.
I shall now recall the principal steps of the procedure in the present case. On the 11th of April 2024, the United Mexican States filed in the Registry of the Court an application instituting proceedings against the Republic of Ecuador regarding legal questions concerning the settlement of international disputes by peaceful means and diplomatic relations and the inviolability of a diplomatic mission. In particular, Mexico refers to an incident that occurred on the 5th of April 2024, when Ecuadorian special forces are alleged to have forcibly entered the Mexican embassy in Quito, assaulted personnel of the mission, and removed from the premises of the mission Mr. Jorge David Glass Espinel, former Vice President of the Republic of Ecuador, who had been granted asylum by Mexico. To found the jurisdiction of the court, the applicant invokes Article 36, paragraphs 1 and 2 of the Statute of the Court and Article 31 of the Pact of Bogotá, to which both states are parties. The application also contained a request for the indication of provisional measures, pursuant to Article 41 of the Statute of the Court. Mexico requests the court to indicate provisional measures pending the court's determination on the merits of the case in order, I quote, to protect Mexico's paramount interest in the inviolability and respect of the diplomatic premises, their property and archives, including the residence of its diplomatic personnel formally accredited in Ecuador, and to ensure the court's ability to order the relief Mexico seeks, end of quotation. The Registrar will now read out the passage from the request specifying the provisional measures which the Government of Mexico is asking the Court to indicate. You have the floor, Mr. Registrar. Thank you, Mr. President. The Government of Mexico requests, I quote, A, that the Government of Ecuador takes appropriate and immediate steps to provide full protection and security of diplomatic premises, their property, and archives, preventing any form of intrusion against them. B, that the Government of Ecuador allows the Mexican government to clear diplomatic premises and the private residence of diplomatic agents. C, that the Government of Ecuador ensures that no action is taken which might prejudice the rights of Mexico in respect of any decision which the court may render on the merits. D, that the Government of Ecuador refrains from any act or conduct likely to aggravate or widen the dispute of which the court is seized." End of quotation. I thank the Registrar. Immediately after the application and the request for the indication of provisional measures were filed, the Registrar transmitted an original copy thereof to the Government of Ecuador. He also notified the Secretary-General of the United Nations. According to Article 74, Paragraph 1 of the Rules of the Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the Court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the oral proceedings in such a way as to afford the parties an opportunity of being represented at the hearings. The Court decided that these oral proceedings would open on the 30th of April 2024. I would now like to welcome the delegations of the parties. I note the presence of the Agents and Council of Mexico and Ecuador. This morning, the Court will hear the single round of oral argument of Mexico, which has submitted the request for the indication of provisional measures. It will hear the single round of oral argument of Ecuador tomorrow, Wednesday, the 1st of May 2024, at 10 a.m. Both parties have a maximum allotted time of 2 hours each for their respective oral presentation. At today's sitting, Mexico may, if required, avail itself of a short extension beyond 12 noon in view of the time taken up by these introductory remarks. Before giving the floor to the Agent of Mexico, I wish to draw the attention of the parties to Practice Direction 11, which states as follows, I quote, "In the oral pleadings on requests for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the Court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quotation.
Floor to the co-agent of Mexico, His Excellency Mr. Carmen Moreno Toscano. Mrs. Carmen Moreno Toscano. You have the floor, Excellency.
Mr. President, Madam Vice President, distinguished members of the Court, it is an honor and a privilege for me to appear before the International Court of Justice on behalf of the United Mexican States. I wish to express my gratitude to the Court for convening this hearing on the earliest possible date to entertain Mexico's request for the indication of provisional measures in this case in light of the risk and urgency of the situation. In its application and in the accompanying request, Mexico firmly asserts that the Vienna Convention on Diplomatic Relations has been violated and expresses its concern that such violations may recur in the absence of provisional measures. Through this intervention, the representatives of the Mexican state will express the factual and legal grounds upon which this concern is based. With the permission of the Court, the statement by Mexico will be delivered as follows. Mr. Alejandro Celorio Alcántara, legal advisor at the Mexican Ministry of Foreign Affairs, will introduce the context of the present case and the request for provisional measures. Mr. Alfredo Uriel Pérez Manriquez, Director for International Tribunals and Organizations, will deliver a brief recount on the relevant facts. Ms. Liliana Oliva Bernal, International Legal Counsel, will present Mexico's consideration regarding the prima facie jurisdiction of the Court to entertain the present request. Mrs. Fadia Ibrahim Nader, Director for the Settlement of Disputes regarding Privileges and Immunities, will state the rights of Mexico that must be protected, and their link with the provisional measures requested. Mr. Miguel Ángel Reyes Moncayo, Deputy Legal Advisor, will present Mexico's positions regarding the existence of a real an imminent risk of irreparable damage. Finally, Mr. Alejandro Celorio will present this court with Mexico's concluding statement and final submissions. I thank you for allowing me to address you, and now, with the permission of this honorable court, I will ask you, Mr. President, to invite Mr. Alejandro Celorio Alcántara to the podium to present the context of this case and the request of provisional measures.
I thank the co-agent of Mexico for her statement. I now invite Mr. Alejandro Celorio Alcántara to take the floor. You have the floor, sir.
Mr. President, honorable judges, it is an honor to appear before you and to present the context of this case, which must be underscored. Your Excellencies, there are lines in international law which should not be crossed. Regrettably, the Republic of Ecuador has crossed them. The actions undertaken by Ecuador not only transgress the established boundaries of international law, but also have served a disconcerting precedent that reverberates across the international community. This very court has stated, in the hostage case, that the inviolability of diplomatic premises is a rule protected by the Vienna Convention on Diplomatic Relations, which has binding force upon both the states party to the present dispute. Moreover, it has asserted that this rule is of a fundamental character. With its actions, Ecuador has infringed upon one of the cornerstones that governs the relationships between states. The Secretary General of the United Nations has taken a stance regarding the matters of the case at hand. A day after the violent and aggressive incursion by Ecuador into the Mexican embassy, the Secretary General released a statement emphatically reaffirming that, and I quote, "The cardinal principle of the inviolability of diplomatic and consular premises and personnel must be respected in all cases in accordance with international law." End of quote. At the core of this case lies not only the egregious transgression against Mexico, but also the legal certainty of every other sovereign state, international organization, and tribunal in the sacrosanct principle that govern the inviolability of diplomatic premises and personnel, a tenet this honorable court has deemed a cornerstone for the conduct of relations between states. The forceful and violent incursion of Ecuadorian authorities into the premises of the Mexican embassy and the unjustified exercise of violence against members of our diplomatic mission, alongside the blatant attempt to justify a grave violation of international law, vividly showcase Ecuador's disregard for fundamental, universally accepted, and long-standing norms. This conduct creates an imminent risk that another violation could occur. A worrisome doubt arises about the true intentions of Ecuador now that the Mexican diplomatic premises and private residences are vacant, with documents and property therein that might be of the interest of Ecuador. In addition, the abrupt and inexplicable change of dynamics that took place on April 4 and 5th deepens our skepticism. Notwithstanding the extensive diplomatic dialogue, including the exchange of information regarding the asylum request of Mr. Jorge David Glass, the former Vice President of the Republic of Ecuador, and even after the declaration of the Mexican ambassador as persona non grata, along with the exchange of notes verbal concerning the request and denial of entry to the premises, diplomatic personnel witnessed a heightened level of surveillance imposed by Ecuador that resulted in the assault of our embassy. Ecuadorian authorities not only breach international law, they exhibit willful negligence that pose an enormous risk to the security and lives of the members of the mission. Had the gun aimed at the Mexican Deputy Chief of Mission been fired, we will now be addressing a far more serious and irreparable violation of international law. The declarations made by Ecuador's authorities after the incident, instead of allaying our concerns regarding a potential recurrence of breaches to the inviolability of our premises and archives, only serve to exacerbate them. While we acknowledge and are mindful of the security situation in Ecuador and of the measures implemented by its government to address it, we remain determined in recognizing that this circumstance cannot serve as an exemption to Ecuador's obligations under the Vienna Convention. There is no rule under international law that could nullify the inviolability of the Embassy of Mexico, and no standard under which the assault could be deemed as a lawful operation. The inviolability of diplomatic premises is even recognized under Ecuadorian law, which explicitly states, and I quote, "Diplomatic premises, consular offices, and those of international organizations, as well as their belongings and archives, will be inviolable and will enjoy immunity against search, requisition, confiscation, expropriation, and any other form of intervention." End of quote. This law makes no distinction regarding acts of authority ordered by administrative, executive, judicial, or legislative authorities. It must be stressed that throughout this ordeal, Mexico consistently adhered to international law. Nevertheless, despite Mexico's compliance, the inviolability of its premises and diplomatic personnel was violated. There is not a valid justification for the incursion that occurred on April 5th, nor for the harassment in the preceding days. Let me be clear. There will never be a valid justification for any breach of international obligations owed to Mexico. States cannot invoke internal dispositions like the measures taken by Ecuador to address its security situation to exempt themselves from complying with their international obligations. This court has the opportunity to firmly reiterate this well-known principle of international law by granting the provisional measures that Mexico respectfully asks for. This case is not only of concern for Mexico. 68 states and international organizations, both at the regional and universal level, have united to express solidarity with Mexico and their disapproval to Ecuador's actions. The international community has lost confidence in Ecuador's commitment and capacity to honor its most basic obligations under international law, raising justified concerns of potential recurrence of similar breaches. Your Excellencies, it is most likely that Ecuador will attempt to justify its disregard for international law and its attack on the Mexican embassy. First, Ecuador might allege that through the protection and eventual granting of asylum to Mr. Jorge Glass, Mexico supposedly violated Article 41 of the Vienna Convention. Second, Ecuador might also argue that the granting of such status was against the 1954 Caracas Convention on Diplomatic Asylum. Mexico will certainly, in due course, provide this court with information that supports the legality of its decision on national law. However, as clearly stated in Practice Direction 11, adopted by this court, This hearing shall only address the request for provisional measures submitted by Mexico, and not the merits of the case. Distinguished judges, the assault on the Mexican embassy unequivocally constitute a breach of the inviolability of the diplomatic premises and personnel. No credible and reliable assurance has been provided to prevent further violations, nor has there been full acknowledgement by Ecuador of its obligations to refrain from entering the Mexican premises. Therefore, we respectfully ask this court to grant provisional measures pursuant to the applicable provision of the statute. With the permission of the court, I would ask you now, Mr. President, to give the floor to Mr. Alfredo Uriel Perez Manriquez to present the facts which the request for provisional measures is based.
Thank you. I now give the floor to Mr. Alfredo Uriel Perez Manriquez. You have the floor, sir.
Honorable members of the court, I stand before you to recount the harrowing sequence of events leading up to the blatant violation of international diplomatic law by the government of Ecuador against the premises of the Mexican embassy. These events represent an unfortunate and pivotal precedent that stresses the imperative necessity to grant provisional measures. On the night of April 5th, 2024, Ecuadorian Special Operation agents forcibly entered the Mexican embassy in Quito. Approximately 15 agents and a couple of vehicles raided the embassy. During this raid, our Deputy Chief of Mission, Mr. Roberto Canseco Martinez, was subjected to physical assault while attempting to prevent the illegal intrusion and subsequent apprehension of Mr. Glass, who at the time of the events was under our protection in accordance with both Mexican and international asylum law. These actions egregiously violate the sanctity of diplomatic missions as enshrined in international law. Unfortunately, these were not isolated events, but rather the culmination of a sequence of intimidation and harassment tactics directed against the Mexican diplomatic mission since Mr. Glass' arrival at the embassy on December 17, 2023. Considering the circumstances of persecution targeting individuals affiliated with the political party of former President Correa, Mr. Glass was sought asylum to protect his life and personal safety. Following his formal application for asylum, the embassy and diplomatic personnel were subjected to constant surveillance by Ecuadorian authorities, evidencing a systematic disregard for diplomatic norms. In response, Mexico initiated diplomatic efforts exemplified by high-level meetings between Mexican and Ecuadorian foreign affairs representatives, aimed at resolving the situation through peaceful diplomatic dialogue. Despite these efforts, the situation escalated as evidenced by Ecuadorian Foreign Ministry's request in early 2024 to enter our embassy to detain Mr. Glass, a request our government denied. This refusal was notified by a note verbal transmitted to Ecuador on March 4, which also requested all necessary means to safeguard the integrity and inviolability of the diplomatic premises of Mexico. However, these diplomatic efforts were met with increasing hostility. By April 4th and 5th, Ecuador has drastically intensified its actions against Mexico. Firstly, Ecuador declared Mexico's ambassador, Raquel Cerur, as persona non grata. Secondly, Ecuadorian authorities significantly increased surveillance and harassment tactics by police forces in the vicinity of the embassy. All this culminated in the violent events of April 5th. In the morning of April 5th, the President of Mexico publicly requested the support of the Mexican Air Force to retrieve our ambassador in order to vindicate her dignity and guarantee her return to Mexico. Later that day, a press release, Mexico protested the decision to declare our ambassador as persona non grata, as well as the increase of Ecuadorian police presence at the embassy. Additionally, Mexico announced its decision to grant asylum to Mr. Glass and the intention to request a safe conduct to transfer him from Ecuador through diplomatic means. In a press release issued on April 5, 2024, shown as Annex 2 on the judge's folder, the Ecuadorian Ministry of Foreign Affairs gave false assurances to Mexico, stating that, and I quote, "In strict compliance with the norms of the Vienna Convention, it would continue to provide protection to the premises of the Mexican Embassy in Quito." End of the quote. However, as this honorable court will note, Ecuador did not keep its word. Up to this point, and albeit the disturbing presence of security forces, Mexico believed that the diplomatic dialogue could prevail. Surprisingly, the Republic of Ecuador deployed a military-style operation in the vicinity of the embassy, and around 10 p.m., personnel of Ecuadorian security forces entered the Mexican embassy without authorization. In the video which will be shown, this honorable court will observe that Ecuadorian agents scaled our walls, forcibly knocked down the door, subdued the private police officer of the embassy, assaulted our diplomatic personnel, and forcibly subtracted Mr. Glass. Honorable members of the court, as shown in the video, the operation not only entailed the physical assault of Mr. Canseco, but also a significant violation of his personal dignity, as he was pointed at with a firearm and forcibly restrained. It is crucial to note what it seems the disabling of communication devices during the raid, a tactic that points to a premeditated effort to isolate our staff during these critical moments. As these events demonstrate, the raid was carried out in a violent and premeditated manner. Although there were only unarmed diplomatic personnel in the embassy, Ecuador decided to deploy an operation with tactical and military-style equipment with long firearms to subdue whoever was necessary. This also demonstrates Ecuador's capacity and intention to carry out this type of operation whenever they deem it necessary, bypassing the norms of international law. In light of these severe violations and the sustained threat to the safety and dignity of our diplomatic personnel, Mexico was compelled to break off diplomatic and consular relations with Ecuador. As a consequence, our diplomatic premises are empty and unprotected from any actions Ecuador may take to re-enter, inspect, seize, or damage Mexico's property and archives. Ecuador's actions demonstrate its disregard for international law, which is why Mexico is turning to the court to request provisional measures. This, Your Excellencies, concludes my presentation on the factual background to the present dispute. I am grateful for your kind attention. With the permission of the court, I would ask you now, Mr. President, to give the floor to Ms. Liliana Oliva Bernal, who will present how this court has prima facie jurisdiction in the present request.
I thank Mr. Alfredo Uriel Perez Manriquez for his statement. Je donne à présent.
I now give the floor to Ms. Liliana Oliva Bernal. You have the floor, madam. Mr. President, Madam Vice President, members of the court, it is a great honor for me to appear before the court today on behalf of Mexico. As stated by Ambassador Moreno Toscano, in my oral pleadings, I will address the question of the court's prima facie jurisdiction to indicate the provisional measures requested here. As confirmed several times by your own jurisprudence, in proceedings for indication of provisional measures, the court need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. On the contrary, at this stage, the court is only called upon, and I quote you from Avena, to decide whether the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded. End of quotation. Mr. President, members of the court, in this instance, Mexico clearly satisfies this criterion. This dispute has been brought before you, taking as the basis for the court's jurisdiction Article 31 of the Pact of Bogota, which provides as follows, and I quote, "In conformity with Article 36, Paragraph 2 of the Statute of the International Court of Justice, the high contracting parties declare that they recognize in relation to any other American state the jurisdiction of the court as compulsory ipso facto without the necessity of any special agreement so long as the present treaty is in force in all disputes of a juridical nature that arise among them concerning A. the interpretation of a treaty, B. any question of international law, C. the existence of any fact which, if established, would constitute the breach of an international obligation, and D. the nature or extent of the reparation to be made for the breach of an international obligation. End of quotation. This is not the first case in which the court confirms that it has jurisdiction on the basis of the Pact of Bogota. In fact, this treaty has served that purpose in close on 20 cases. What is more, in certain activities carried out by Nicaragua in the border area, the court stated that it did have prima facie jurisdiction in Costa Rica's request for the indication of provisional measures on the basis inter alia of the Pact of Bogota. Members of the court, the Pact of Bogota provides for two conditions to be met to grant jurisdiction to the court. Firstly, the existence of a legal dispute linked to the matters set out in Article 31 of that pact, and secondly, that both parties shall beforehand have attempted to settle their disputes through direct negotiations following the customary diplomatic channels. As regards the first of these conditions, let me recall that after the regrettable events of the 5th of April and the breaking off of diplomatic and consular relations announced by Mexico on the 6th of April, Ecuador's Minister of Foreign Affairs on that same day published a press release, which is to be found in Annex 3 of your file, which justified the actions of the Ecuadorian special forces by claiming a so-called violation by Mexico of Article 41 of the Vienna Convention on Diplomatic Relations. This same argument was reiterated by the Deputy Minister of Foreign Affairs, Alejandro Dávalos, when on the 9th of April he declared, and this was at a special meeting that was convened by the Permanent Council of the Organization of American States to settle this conflict, this dispute between Mexico and Ecuador, that Mexico's actions were contrary to Article 41 of that convention. Mexico has made several approaches, both bilaterally and multilaterally, in order to express and clarify its position on the rules of international law at issue in this case. These approaches include, amongst other things, a letter that was sent to the Secretary General of the United Nations, dated the 12th of April, and which is to be found as Annex 4, referring to the grave violations committed by the Republic of Ecuador against the premises and diplomatic staff of Mexico's embassy in that country. The differences between the two states concerning the obligations under the Vienna Convention, members of the court, could scarcely be more acute. On the one hand, Mexico is stressing the fact that, as regards inviolability of diplomatic premises and diplomatic personnel, brooks no exception under international law. Ecuador has attempted to justify the violation of its obligations under the Vienna Convention.
As the court observed in the Marshall Islands case, in order for there to be a dispute, the two parties' points of view regarding the fulfillment or non-fulfillment of certain international obligations must be clearly opposed. End of quote. Mexico and Ecuador clearly do not have the same view of how they should fulfill obligations arising from the Vienna Convention, and that clearly proves that a legal dispute between Mexico and Ecuador did exist when the application institution proceedings was filed, and that the dispute still exists and is even growing. As regards the second condition, please allow me to remind you of Article 2 of the Pact. Quote, "The high contracting parties recognize the obligation to settle international controversies by regional procedures before referring them to the Secretary-General of the United Nations. Consequently, in the event that a controversy arises between two or more signatory states, which, in the opinion of the parties, cannot be settled by direct negotiations through the usual diplomatic channels, the parties bind themselves to use the procedures established in the present treaty, in the manner and under the conditions provided for in the following articles, or, alternatively, such special provisions as, in their opinion, will permit them to arrive at a solution." End of quote. Here, the Court is right to say that Article 2 of the Pact is a precondition of using the Pact's peaceful procedures. It therefore follows that the Court must examine how this condition applies in the case before us. Today, we shall remember that, following diplomatic efforts seeking a solution to the dispute between the parties, and Mexico's refusal to grant access to its diplomatic premises, the Ecuadorian authorities launched an operation to storm the Mexican embassy and abduct Mr. Glass, rather than embarking on negotiations on the subject. After the attack, ladies and gentlemen of the Court, the Ecuadorian Ministry of Foreign Affairs said in a press communiqué dated 6th of April that it had exhausted all diplomatic paths towards the settlement of the dispute. President, ladies and gentlemen of the Court, Ecuador's actions against Mexico have not only aggravated the conflict, but they have also proved that there was no reasonable chance of attempting to settle the dispute by diplomatic negotiations. Therefore, the conditions the Pact of Bogotá sets for having recourse to the Court are already fully met. I would further remind you that the treaties on the basis of which Mexico accords competence to the Court in this case were in force between the parties when the application instituting proceedings was filed, and remain so. Mexico has been party to the Vienna Convention on Diplomatic Relations since 1965, and Ecuador has been since 1964. As regards the Pact of Bogotá, Mexico has been a party since 1948, and Ecuador has been one since 2008. All this goes to show that the criteria establishing jurisdiction for your court, ratione materi, ratione temporis, and ratione personi, are plainly met in the present case. Finally, I would draw the Court's attention to the fact that Ecuador has never disputed the Court's jurisdiction. And this is a good thing too, because Article 31 of the Pact of Bogotá is manifestly applicable to today's dispute. Mr. President, honourable judges, the two states are parties to the Vienna Convention on Diplomatic Relations and the Pact of Bogotá. The conditions the pact sets out for seizing the court have been met. There is a dispute connected to a treaty currently in force between the parties, to be precise, the Vienna Convention. Mexico takes a view, therefore, that you have prima facie jurisdiction to order provisional measures in accordance with criteria specified by the court itself. With those conclusions, ladies and gentlemen of the court, I end my pleading, and I would like to thank you for listening to me so carefully. President, may I now ask you to call Ms. Fadia Ibrahim to the bar. Thank you very much.
Madame Liliana Olivia Bernard.
Thank you very much.
Fadia Ibrahim Nader to take the floor. You have the floor, madam.
Mr. President, Madam Vice President, distinguished members of the court, it is a great honor for me to appear before you on behalf of Mexico. Today, I will address the rights that Mexico seeks to preserve through its request for provisional measures. These rights are fundamentally straightforward, as they pertain to the fundamental rules underpinning diplomatic relations between states. Specifically, I am referring to the inviolability of diplomatic premises, their property, and archives. At this stage of the proceedings, the court is not called upon to definitely determine the existence of the rights Mexico seeks to protect. Instead, this court is solely required to decide whether the rights claimed by Mexico on the merits and for which it is seeking protection are plausible. In the case at hand, the rights asserted by Mexico not only meet but significantly exceed the threshold of plausibility, as they are explicitly granted by the Vienna Convention. Therefore, I would like to draw your attention to the rights and corresponding obligations outlined in the Vienna Convention, 2, the link between said rights and the provisional measures requested, and 3, the complementary provisional measures needed to preserve those rights. The Vienna Convention was concluded bearing in mind the purpose and principles of the Charter of the United Nations concerning the sovereign equality of states, the maintenance of international peace and security, and the promotion of friendly relations amongst nations. The principle of inviolability stands as a core requisite to conduct diplomatic relations between states. This right is explicitly enshrined in the Vienna Convention in Article 22 for diplomatic premises and Article 24 for archives and documents of the mission, and in Article 30 for the private residences of diplomatic agents. This court has previously stated the fundamental relevance of inviolability, as it did in the United States diplomatic and consular staff in Tehran, and I quote, "Whereas there is no more fundamental prerequisite for the conduct of relations between states than the inviolability of diplomatic envoys and embassies, so that through history, nations of all creeds and cultures have observed reciprocal obligations for that purpose." Whereas, while no state is under any obligation to maintain diplomatic or consular relations with one another, yet it cannot fail to recognize the imperative obligations inherent therein, now codified in the Vienna Conventions of 1961 and 1963. End of quote. Therefore, honorable members of the Court, there is no doubt as to the critical importance of the principle of inviolability, which prevails in all situations, with no exemptions. As affirmed by Article 45 of the Vienna Convention, which states that in case of breach of diplomatic relations between two states, the receiving state must respect and protect the premises of the mission together with its property and archives. Article 45 describes an obligation for the receiving state, which correlates to the right of the sending state to have its diplomatic premises, property, and archives respected and protected. This court interpreted in its provision in the hostages case, observing that, and I quote, "The fundamental character of the principle of inviolability is strongly underlined by the provisions of Article 44 and 45 of the Convention of 1961. Even in the case of armed conflict or in the breach of diplomatic relations, those provisions require that both the inviolability of the members of a diplomatic mission and of the premises, property, and archives of the mission must be respected by the receiving state." End of quote. Thus, Article 45 is the source of the right that Mexico seeks to preserve, and it applies to the present dispute since April 6th, 2024. On this date, Mexico notified, through a note verbal, the termination of diplomatic and consular relations with Ecuador. This action was taken in response to the unauthorized intrusion by Ecuadorian authorities into the Mexican embassy in Quito, as well as its heinous acts against diplomatic personnel. Now that both states have severed their diplomatic relations, Ecuador is unequivocally obligated to uphold and safeguard Mexico's diplomatic premises, their property, and archives. The present case revolves around Ecuador's egregious violation to the principle of inviolability under a non-existent justification. Ecuador's actions implied a perceived exemption to the principle of inviolability where none exists. In contrast, Mexico firmly asserts that this principle is of the utmost importance in the conduction of diplomatic relations and that no justification can legitimately exempt its application. The same criteria applies with Article 45, which enshrines the principle of inviolability even when diplomatic and consular relations have been broken off. There are no exemptions to this provision, although the government of Ecuador has expressed that it is of a different view, and that the inviolability of diplomatic premises can be set aside upon the discretion of the receiving state, as evidenced in the press release contained in the judge's folder as Annex 3. Your Excellencies, it is worth mentioning that should the government of Ecuador advance that there may be an exemption to this provision, this would be a matter for the merits. Up to this point, Your Excellencies, it is clear that the rights of Mexico, whose protection is requested, are more than plausible and must be preserved. For these reasons, the government of Mexico seeks from this court to declare that Ecuador must comply with Article 45A of the Vienna Convention in order to undertake all appropriate and immediate measures to ensure the respect and protection of the premises of the mission, its property, and archives. Your Excellencies, the principle of inviolability lies at the heart of this dispute, even following the severance of diplomatic relations. The existence of this principle, along with the rights and obligations they confer upon the concerned parties, is unquestionable. This underscores that the threshold for the plausibility of the right Mexico seeks to preserve before this court have been duly met. Only the preservation of those rights by means of an order of provisional measures may subsequently allow this court to adjudge upon them. Your Excellencies, please allow me to recall the 4 provisional measures Mexico requested before this court in its application for the institution of proceedings. First, that the government of Ecuador takes appropriate and immediate steps to provide full protection and security of diplomatic premises, their property, and archives, preventing any form of intrusion against them. That the government of Ecuador allows the Mexican government to clear diplomatic premises and the private residence of diplomatic agents. 3, that the government of Ecuador ensures that no action is taken which might prejudice the rights of Mexico in respect to any decision which the court may render on the merits. And lastly, that the government of Ecuador refrains from any act or conduct likely to aggravate or widen the dispute of which the court is seized. This court has stated that, in addition to the plausibility of the rights claimed by the requesting state, a link must exist between the rights which form the subject of the proceeding before the court on the merits of the case and the provisional measures being sought. In this regard, Your Excellencies, the first 2 provisional measures Mexico has requested are clearly linked to the right asserted regarding the principle of inviolability embodied in Article 45. The first provisional measure corresponds to the application of the principle of inviolability and its performative character. That is, an obligation upon the concerned state whereby, by means of its own choosing, it is bound to provide protection and security to the mission and its property. This, without the prejudice to the obligation to respect the premises of the mission with its property and archives. Your Excellencies, ordering Ecuador to provide full protection and security of the diplomatic premises, their property, and archives would not only restate the content of this protection as enshrined in the Vienna Convention, it would also respond directly to Ecuador's previous breach of the inviolability bestowed by the Vienna Convention on the Mexican mission, and prevent the real possibility that such violation occurs again. This measure seeks to ensure that Ecuador takes the appropriate and immediate action to thwart any further breach. The second provisional measure naturally follows the severance of diplomatic relations and is essential for the retrieval of all items from the diplomatic premises and private residences of diplomatic agents. This measure is necessary to ensure the safe return of all property and archives to Mexico, minimizing the risk of further transgression by Ecuadorian authorities. In addition to the provisional measures requested to preserve specific rights, this court possesses by virtue of Article 41 of the statute the power to indicate provisional measures with a view to preventing the aggravation or extension of the dispute whenever it considers that the circumstances so require. The Court has on several occasions issued provisional measures directing the parties not to take any action which could aggravate or extend the dispute or render more difficult its settlement, usually accompanying other measures protecting specific rights. Therefore, the last two measures requested by Mexico have a complementary nature and will serve for the protection of its rights provided in the Vienna Convention in order to ensure the orderly administration of justice in the present case. These complementary measures bear similarities to those requested in other cases before this Court, such as certain activities carried out by Nicaragua in the border area, where Costa Rica sought that Nicaragua shall refrain from any other action which might prejudice the rights of Costa Rica or which may aggravate or extend the dispute before the Court. In that case, the Court considered, whereas the final provisional measure sought by Costa Rica, being very broadly worded, is linked to the rights which form the subject of the case before the Court on the merits, and so far, it is a measure complementing more specific measures protecting those same rights. The third and fourth provisional measure seek to ensure that Ecuador will not take any steps to cause further prejudice to Mexico's rights and to safeguard the status quo before the Court decides upon the merits. With the leave of the Court, I respectfully ask you, Mr. President, to give the floor to Mr. Miguel Ángel Reyes Moncayo, who will now delve on Mexico's argument regarding the existence of real and imminent risk of irreparable damage.
I thank Ms. Liliana Olivia Bernal for her statement. I now give the floor to Mr. Miguel Ángel Reyes Moncayo. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court. It is certainly a great honor for me to appear before you as agent for the United Mexican States, in spite of the regrettable circumstances that bring us before this Court today. With the leave of the Court, I will address the element of urgency due to the existence of a real and imminent risk of irreparable damage upon the rights of Mexico. As previously mentioned, Mexico broke off diplomatic relations with Ecuador. Thus, Article 45A of the Vienna Convention establishes that the receiving state must respect and protect the premises of the mission, its property, and archives. Consequently, even in the case of the breach of diplomatic relations, the premises of the mission, including the private residences of the diplomatic agent, its property, and archives, must continue enjoying the status of inviolability established in Articles 22, 24, and 30 of the Vienna Convention. To put in context the irreparable prejudice that the rights and interests of Mexico could suffer, I shall recall the Court that A. Mexico is the owner of the building located at 6 de Diciembre Avenue and Naciones Unidas Street, which housed the premises of the embassy. B. There are lease agreements in force for the private residence of the diplomatic agents of the embassy, including the head of mission. C. Given the sudden departure of the members of the mission, both physical and digital archives and documents of the embassy were left in the diplomatic premises. These contain confidential and sensitive information regarding the diplomatic functions that Mexico performed in Ecuador. Thus, Ecuador is under a performative duty to protect. This duty can be fulfilled by means of its own choosing. However, Ecuador is under an unrestricted obligation to provide full protection and security to the premises, the property, and archives of Mexico from physical invasion or interference and from any impairment to their status. Concerning the irreparability of a prejudice against diplomatic inviolability, in the case of immunities and criminal proceedings between Equatorial Guinea versus France, this court established, and I quote, "Any infringement of the inviolability of the premises may not be capable of remedy, since it might not be possible to restore the situation to a status quo ante. In consequence, any act, omission, or negligence of Ecuador that endangers or infringes the inviolability granted to the premises, property, and archives of the Mexican embassy will cause an irreparable harm to the legal rights and interests of Mexico in the present proceedings." Distinguished members of the court, we cannot go back in time and restore the status quo ante before the violent attack of April 5th on the Mexican mission. The damages suffered by our rights and interests thereby are irreparable. This is why we appeal to this court to issue the provisional measures requested in these proceedings in order to avoid further irreparable damages upon the rights of Mexico protected by the Vienna Convention. Mr. President, Your Excellencies, I will now address how there is a real and imminent risk that justifies the provisional measures requested to the court. This court stated that it will indicate provisional measures only if there is urgency. As previously established by this court, the condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. In this regard, Mexico is deeply concerned about the possibility that Ecuador causes an irreparable prejudice to its right, which it claims pendente lite, and that are enshrined in the Vienna Convention. The concerns of Mexico are based on the following arguments. First, the environment of distrust created by Ecuador as reasonable indication of a risk upon the rights of Mexico. On this matter, we have to bear in mind that the principle of good faith is one of the cornerstone principles of international law. As this court has recognized in the nuclear test case, good faith is a basic principle that governs the creation and performance of legal obligations. Trust and confidence are inherent in cooperation between states. In the context of diplomatic relations, the principle of good faith is of the utmost importance, since only with trust and confidence states develop effective diplomatic relations. It was under those assumptions that Mexico conducted its relationship with Ecuador, since there were reasonable expectations that Ecuador would abide by its obligations and duties under international law. Those expectations were based on, 1, the public defense that Ecuador made about inviolability of diplomatic premises in the case of Mr. Julian Assange for 7 years. 2, its active participation within the framework of General Assembly Resolution 75/139 concerning consideration of effective measures to enhance the protection, security, and safety of diplomatic and consular missions and representatives. 3, the existence of a Diplomatic Immunities, Privileges, and Franchises Act enacted by Ecuador and still enforced today. 4. The note verbal of February 29, 2024, submitted as Annex 5, in which Ecuador asked for Mexico's consent to execute a warrant upon Mr. Glass inside the diplomatic premises. And 5, the statement of April 2nd, 2024, in which the representative of Ecuador to the Security Council of the United Nations reaffirmed the obligations that all states, in accordance with international law, must respect the immunity and inviolability of diplomatic and consular premises. The representative of Ecuador also mentioned that any violation of the Vienna Convention in that regard is a serious incident that causes damage and negatively affects the promotion of the shared values of the international community. All these facts created reasonable expectations for Mexico that Ecuador would comply with its obligations concerning diplomatic privileges and immunities. However, the events of April 5th show that even with these international and national regulations in force, and running counter the position it upheld along years in the case of Mr. Julian Assange, Ecuador decided to act contrary to international law. As previously stated by my co-agent, Ecuador's actions have created an environment of distrust in the region. This is aggravated due to the security policies implemented by the government, including the establishment of 3 states of exception from January to this day, which entail the suspension of rights such as the inviolability of domiciles. Our second argument on urgency is the continuous disregard of Ecuador for the privileges and immunities of Mexico in accordance with the Vienna Convention, which might be indicative of further law enforcement operations into the premises. As previously stated, on February 29, 2024, Ecuador asked for Mexico's consent to enter into the embassy. However, on March 4th, the Mexican Ministry of Foreign Affairs responded through a note verbal that the consent would not be granted and reminded Ecuador of the obligation to respect the inviolability of the premises. Notwithstanding the inviolability, Ecuador illegally entered into the diplomatic premises. Additionally, on April 15, 2024, SBS News published an interview with President Noboa, in which he declared that he did not have any regrets about the illegal entry into the Mexican embassy in Ecuador since, I quote, "they were on the right side of history," end of quote. Later, on April 23rd, Minister Sommerfeld questioned the validity of the Vienna Convention during an interview in the following terms, and I quote, "The conventions on which we are signatories respond to the realities that the world faces today regarding organized crime and all the industries that derive from it. They were created 50 or 70 years ago. I think that today they do not respond to reality," end of quote. Upon the analysis of the aforementioned facts, it becomes evident that there is clear and convincing evidence that although Ecuador, despite being fully aware of the inviolability afforded to the diplomatic premises, property, and archives of the Embassy of Mexico, willingly decided to disregard those obligations. Despite such knowledge, Ecuador proceeded with an illegal raid into diplomatic premises. Moreover, the declarations of President Noboa shows a total lack of respect of international obligations, which, in his view, can be ignored. Finally, since the breaking off of diplomatic relations, The building on 6 de Diciembre Avenue, along with the archives, documents, and other property of the former embassy, remain unprotected and vulnerable to possible damage, confiscation, or inspection from national authorities, or even from private individuals. The urgency of the measures stems from the vulnerability and need for protection based on the possibility that Ecuadorian authorities could try to enter and conduct searches upon the premises, archives, and documents of the embassy due to the habeas corpus judicial procedure initiated by Mr. Glass on April 7, 2024. There could be, moreover, other judicial proceedings involving Mr. Glass, of which Mexico is not cognizant, where search mandates were issued and enforced inside our former embassy in Quito, and the property and documents found therein. The aforementioned bears a striking resemblance to the case Immunities and Criminal Proceedings between Equatorial Guinea versus France, in which this court granted provisional measures due to the fact that there was a risk of intrusion to the diplomatic premises of Equatorial Guinea, since there was a possibility that French authorities could conduct new searches due to pending judicial procedures. In consequence, the arguments previously raised sustain the possibility of a continuous risk of intrusion and confiscation upon the premises, property, archives, and documents of the former Mexican embassy. It is also important to mention, Your Excellencies, that Ecuador did not provide any appropriate and credible assurances to Mexico that its rights under the Vienna Convention will be respected. Mexico recognizes that on April 9, 2024, the Ministry of Foreign Ecuador sent a note verbal, as shown on Annex 6 in the judge's folder, assuring the respect and the protection of diplomatic premises, property, and archives in accordance with Article 45A of the Vienna Convention. However, such note verbal did not mention anything about its duty to protect its inviolability. Furthermore, it is important to recall that on April 5th, 2024, hours after the declaration of persona non grata of our ambassador through a press release, as shown in the judge's folder as Annex 1, the Ministry of Foreign Affairs informed that the government of Ecuador was going to respect and comply with its obligations under the Vienna Convention. Nevertheless, in the course of the night, Ecuador orchestrated a police operation at the embassy doing the opposite. Moreover, in the frame of the present proceedings, on April 19th, 2024, through a note verbal of its embassy to the Netherlands, Ecuador reiterated its acknowledgement of its obligations under the Vienna Convention, along with assurances to this court and to Mexico that it would respect and protect the premises of the Mexican embassy in Quito. Those same acknowledgements and assurances were given to Mexico on April 5th, just before raiding the embassy. It is true that this court has recognized that an undertaking by the respondent state might deprive the urgency character of the request, like in the case, questions relating to the obligation to prosecute or extradite. However, in the case of certain documents and data case, even though it was considered that a written undertaking of the respondent state makes a significant contribution towards mitigating the imminent risk of irreparable prejudice, this court concluded that the undertaking did not remove the risk in its entirety. In the present case, both notes verbal may seem as a commitment by Ecuador to respect and protect the premises, property, and archives of Mexico in terms of Article 45 of the Vienna Convention. However, in the hostages case, this court established that the same article requires the respect of the inviolability of the premises, property, and archives of the mission. Without a credible and express commitment from Ecuador to respect the inviolability of the Mexican mission, its property and archives, both notes verbal fall short on Ecuador's obligations and, therefore, the imminent risk and the urgency of the measures remain. It must be recalled, moreover, that Minister Sommerfeld mentioned at an interview submitted by Mexico as Annex 8 that the Ecuadorian Ministry of Foreign Affairs only has informative and advisory functions within the government, and that said ministry has no final word concerning security strategies like the one deployed against the Mexican embassy. Hence, it is reasonable to conclude that the assurances given by the Ministry of Foreign Affairs are insufficient, since other government agencies or departments might act on their own. The above mentions, note verbal, do not provide credible and appropriate assurances that Ecuador will quash each and any risk upon the premises, property, and archives of the former embassy. Furthermore, the notes do not remove the risk nor the sense of urgency to grant the provisional measures requested by Mexico. On the contrary, only a binding order of provisional measures from this court will provide the necessary assurances to Mexico that its rights will be protected pending litigation. Thus, if Ecuador fails to comply with the provisional measures dictated by this court, Mexico may recourse to one of the compliance mechanisms established within the UN Charter. In the present state of diplomatic relations, the issuance of the requested provisional measures is imperative to establish a vital precedent affirming the absolute inviolability of diplomatic premises, property, and archives under all circumstances. It is essential to compel Ecuador to adhere to the fundamental principles enshrined in the Vienna Convention and customary international law. Mr. President, members of the Court, I thank you for your attention. I kindly ask you, Mr. President, to give the floor again to Mr. Alejandro Celorio to conclude the oral pleadings on behalf of the United Mexican States.
I thank Mr. Miguel Angel Reyes Moncayo for his statement. I now give the floor back to the agent of Mexico, Mr. Alejandro Celorio Alcantara. You have the floor, sir.
Honorable judges of the International Court of Justice, I am honored to conclude Mexico's oral pleadings and make Mexico's final submissions regarding its urgent request for the indication of provisional measures. Let me reiterate Mexico's gratitude for the opportunity to present before this court our request for the indication of provisional measures, along with the facts and legal considerations that support this petition. Mexico is satisfied that this court has jurisdiction to entertain the request, that we are entitled to rights that must be protected, that these rights face a real and imminent risk of irreparable damage, and that they bear a link with the provisional measures that we respectfully ask this court to grant. It is important to note that in addition to Ecuador's obligation to respect and protect the premises of the diplomatic mission, as well as its properties and archives in accordance to Article 41 of the Vienna Convention, Ecuador is also obligated under the Convention on the Prevention and Punishment of Crimes against International Protected Persons, including diplomatic agents, to sanction any violent attack against the official premises of Mexico and any threat to commit such an attack. This orchestrated raid against the premises and diplomatic staff of Mexico poses a serious threat to the maintenance of international relations and is a cause of grave concern for the international community. In this regard, through these measures, Mexico seeks to protect its premises, properties, and archives and ensure that incidents like the one on April 5 do not recur while the merits of this case are being decided. Ecuador's actions demonstrate its disregard for international law, which is why Mexico is turning to the court to request provisional measures. The discrepancies observed in Ecuador's declarations and conducts prevent Mexico from fully trusting its assurances. Consequently, Mexico is seeking the imposition of provisional measures, which are binding for states to ensure that Ecuador's adherence to its international obligations is not left to its own discretion. For the aforementioned reasons, we respectfully request, on behalf of the Government of Mexico, that pending final judgment in this suit, the Court indicate the following provisional measures. A, that the Government of Ecuador refrains from acting against the inviolability of the premises of the mission and the private residences of diplomatic agents, and that it takes appropriate measures to protect and respect them, as well as the property and archives therein, preventing any form of disturbance. B, that the Government of Ecuador allows the Mexican government to clear diplomatic premises and private residences of diplomatic agents. C, that the Government of Ecuador ensures that no action is taken which might prejudice the rights of Mexico in respect of any decision which the court may render on the merits. D, that the Government of Ecuador refrains from any act or conduct likely to aggravate or widen the dispute of which the court is seized. Mexico respectfully requests the court to affirm the necessity of adhering to international norms and to grant the requested provisional measures, ensuring violations of the inviolability do not recur. Through your decision, this honorable court can reaffirm to the world the importance of the law on privileges and immunities and the international rule of law. On behalf of the Government of Mexico, I thank you for your attention in this matter. This concludes Mexico's presentation this morning.
I thank the agent of Mexico, Mr. Alejandro Celerio Alcantara, whose statement brings to an end the single round of oral argument of Mexico, as well as this morning's sitting. The court will meet again tomorrow, Wednesday, May 1, at 10 a.m. to hear Ecuador present its single round of oral argument. The sitting is adjourned.